Okay, so can you hear me now? Yes, we'll try for the best. If you can't hear me, you can't ask any questions, so that is maybe a positive thing. Thank you very much to Piera and Sylvain for giving me the opportunity to tank some winter sun. We don't get very much of that in Scotland, and to Jeremias for organising this project, which has been very interesting and very challenging. A number of caveats before I start. This presentation is part of a bigger research project that I've been working on for a number of years, and it's specific to that research project. And it looks at the effects or the responses of trade unions in a number of EU member states to the challenges of the recent EU enlargements in 2004 and 2007. And what I'm interested in looking at is how trade unions respond to increased migration following the EU enlargements, and what that tells us about the challenges of the EU enlargements for the national labour law systems in these member states, and what trade unions can learn from each other in how to better respond maybe to the enlargements. And as part of that process, I am interested in also considering the kind of laws that might help trade unions in better responding to the challenges of EU enlargement. So it's not, I don't want to give a general overview of laws that would help trade unions. I don't think that's realistic, at least in this time frame, but it's specific to the challenges of EU enlargement. So what I want to do in this paper is first of all to start by looking at the kind of functions that trade unions adopt in the 5 member states that I'm looking at, and I forgot the 5th one on the slide. So Austria, Germany, Ireland, Sweden and the UK. And the point of looking at the functions is that I realise that there are very different industrial relations systems, and it's difficult to do a comparison. We can talk more about that in the discussion. But I would argue that there is sufficient overlap in the type of functions that trade unions adopt within those systems, even though they vary in their specificities, but sufficient overlap in the type of functions that they adopt, and also sufficient overlap in the types of challenges facing trade unions following the recent EU enlargements. So a second section of the paper considers the challenges of the EU enlargements for trade unions in these 5 member states. And the final section considers the kind of laws that trade unions ought to want in order to better respond to those challenges. So I'm going to very briefly talk about the first and second section, but focus mainly on the third section. And if there are any questions, then we can talk about it in the discussion, and I would welcome your feedback on whether this works. So, in terms of functions then, I borrow Keith Ewing's 5 principal functions of trade unions. I think he gives quite a broad overview, which is very helpful. And these are the service function, a representation function, a regulation function, a government function, and a public administration function. And trade unions in all of the 5 member states adopt these functions to a greater or lesser extent. But most important, I think, in all cases, is regulation and representation, primarily through collective bargaining. So, these functions, I think, have been challenged by the recent EU enlargements, which are unprecedented in the history of the European Union, and particularly by the increase in migration following the enlargements. And migration, I mean inner EU migration, I'm limiting myself to looking at the increase in free movement of workers, posted workers, and so on. So, EU enlargements have challenged trade unions in a number of ways. First, there's a fear that new member state workers may avail themselves of their free movement rights to threaten the economic and social position of workers and trade unions by engaging in so-called social dumping. And also trade unions struggle to integrate these new member state workers into their structures, and as a result, new member state workers frequently suffer from unfair employment practices, and there's more than enough empirical evidence to support this. And this creates tensions within the labour market between groups of workers, which trade unions, I think, at present are badly placed to counter by adopting the traditional functions which they often rely on. And finally, the EU's policy of Europeanising national labour law systems through hard, soft law mechanisms has also had an effect on the environment within which trade unions act, by creating a difficult interface between free movement law and national labour regulation, which has not been, I think, adequately resolved by the EU legislature. And for European trade unions, the incomplete nature of the EU social dimension, coupled with the Court of Justice's recent case law, which we're all very familiar with, have changed and to an extent complicated the environment within which unions have to react to the increased free movement of workers following the enlargement. And they've responded to this in various ways, and I would argue, or I want to argue, that law can be one form of a response. So I think it is timely to consider the kind of laws the unions ought to want. So, the title, The Kind of Laws the Unions Ought to Want, is borrowed from a book written by Clive Jenkins and J.E. Mortimer, who were writing in 1968 in the UK. And they make a convincing case in their book for a legal framework which not only protects trade union rights, but also establishes minimum labour standards. Now, such laws are not designed to replace voluntary action by trade unions, but to complement it by creating a framework within which effective collective bargaining can take place. So one of the predominant functions. And this harks back to Sidney and Beatrice Webb's analysis, so to English socialists writing in the late 19th, early 20th century, which foresaw multiple methods of trade unionism, so mutual insurance, collective bargaining, and legal enactment. According to the Webbs, the increasing power of industry would mean that, and I quote, "the only available method of securing a common rule is legal enactment, difficult in the face of interests so powerful for the trade unions to obtain, but once obtained, easy of application and enforcement." Now, whether all of that is true is open to debate, I think, but I find it interesting, or when I read that, I think it was originally written in the late 19th century, I find it very pertinent for the challenges facing trade unions today as well. So, regulatory challenges facing trade unions following the enlargements make collective bargaining increasingly difficult, particularly in those sectors where new member state workers are prevalent, but trade union organisation tends to be low. And powerful interests described by the Webbs can now be found both at a national and European level, I think, and threaten to undermine established national industrial relations systems. Nonetheless, if successful, I think legal enactment provides an alternative or complementary method for trade unions with which they could both facilitate the integration of new member state workers into their host labour markets and define a new role for themselves in their national labour law systems to ensure their continued relevance as institutions. Now, the precise content of such laws will no doubt vary from one legal system to another, but I would like to make a number of general suggestions in light of the challenges facing trade unions following the recent enlargements. So first, and I struggled here to find laws that could be of interest to trade unions across a broad number of member states. So the next slide might be slightly underwhelming. So first, I would suggest that trade unions need laws which guarantee the right to freedom of association. And second, they require laws which establish a floor of rights for all workers. Now, because of the effects of Europeanisation on national labour law systems, consideration has to be given as to whether these legislative demands should be made at an EU level in order to alleviate the negative consequences of Europeanisation. But limited EU competence restricts the opportunities for legislative developments at the EU level. And I'll deal with this in relation to each of these two categories. So, first of all, the right to freedom of association. So the right of workers to organise in a trade union has long been recognised as a fundamental right, and we heard more about this yesterday. It's enshrined in various international instruments and includes the right to collective bargaining and the right to take collective action. However, the right to freedom of association within all of the member states that I look at is not complete. So what do I mean by complete? The Webbs define complete freedom of association as a situation where the law leaves trade unions as much as possible alone, but also allows trade unions to systematically regulate conditions of employment. And this raises a conundrum, I think. So you want the law to leave trade unions alone, but at the same time you need the state to regulate. So it's quite a difficult balance to achieve, and that conundrum is also recognised in the ILO Conventions 87 and 98. Now, complete freedom of association So complete freedom of association is in theory guaranteed at an international level, but its practical protection is far from assured in all of the countries at issue in this paper. In some cases as a result of national developments, and the UK immediately springs to mind here, but in all cases as a consequence of the court's case law, of the European Court's case law. So in individual member states, trade unions should seek laws which give practical effect to the rights enshrined in international agreements. But I think more importantly, this is a right where the EU level is relevant. And there are a number of ways, I think, in which trade unions could push for the right to freedom of association to be recognised in a more effective way at an EU level. The issue, of course, is that the EU's competence is limited in this sphere. And any protection takes place largely through the status of the right as a fundamental right now enshrined in the Charter. And there's a vast amount of, or a growing amount of literature on protection of collective rights in the Charter. Now, the effectiveness of the provisions of the Charter will depend on the Court's interpretation, and the case law so far has not been overly promising. Nonetheless, I think there are a number of options for the right to freedom of association to be protected at EU level. And I recognise that some of these suggestions might be rather illusory, but I am an eternal optimist, so here's hoping. So first of all, trade unions could petition for protection of the right to strike through EU legislation. And there have been proposals such as the Social Progress Protocol. Also, Article 153 of the treaty expressly excludes EU competence in respect of the right to strike, but this has not prevented the Union from using alternative legal bases in the past. And finally, the Charter, I think, might offer a potential linchpin, especially in light of the EU's accession to the ECHR, which has to happen at some point. I'll leave it there because I'm running out of time, and talk about minimum labour standards. So whereas I think freedom of association needs to be regulated primarily at an international level, minimum labour standards should be regulated at a national level. Now, trade unions in all 5 countries that I examine are struggling to effectively challenge the employer's conduct in those sectors where trade union membership and consequently collective bargaining rates and collective agreement coverage is low. And this includes the service and agricultural sectors and so on, which have a high proportion of new member state workers. Now, for trade unions, there are a number of options of how to respond to these developments. Either, and some of this is country specific, either to lobby for a system whereby agreements can be declared universally applicable, or to support legislation which establishes minimum labour standards that apply to all workers. In the case of minimum labour standards, such legislation needs to provide a clear role for trade unions to play, not only in its regulation, but also in its enforcement. And here, I think, is where the EU level could be relevant, whereby whenever, for example, legislation is adopted, EU legislation is adopted, provisos should be made for trade unions to be involved in the implementation of directives. Directive 2014-54 has this as a voluntary option, but at least it is a starting point. And yes, but apart from encouraging the involvement of the social partners in the implementation of EU legislation, I think this is an area where regulation should occur at a national level, and specifically by involving trade unions in the regulation and enforcement of minimum labour standards. And I can go into that in more detail in the question, but I imagine my 3 minutes are up, so I'll stop. Thank you.
Thank you very much. Thank you very much.